Hello and welcome to the Health, Occupations, and Long-Term Care Subcommittee. Apologize, we're starting a few minutes late. It's that time of session. We have a lot going on. We have 12 bills on the agenda, 13 bills. It's a lot of bills on our agenda today. So we are going to try and get through the ones that are simple and just need amendments first, and then we will move on to the ones that require further discussion. So with that, the first bill we're going to take up is Senate Bill 745, Health Occupations, Massage Therapy Examiners Revisions, which is Senator Alfred's bill. They have our cross file over in the Senate, and I understand they're adopting this same amendment over in the Senate. I think Tyler has this bill, so you can explain to us what the amendment does, but I'll just, for the benefit of the committee, we inadvertently struck some language that the insurance carriers were concerned about. So we want to just make sure it's back in the bill so that we don't have any conflict and everybody's happy. Tyler?
Yes, Senate Bill 745, cross-filed with 1039. It came to us identical to how the House passed 1039. The amendment in question and excerpt of the reprint is page 11 of the packet of amendments that Lisa sent out this morning. So page 11 of the PDF. As you can see, it's pretty short there. And then a reprint is below that if you prefer looking through there. And what it does is restore, it removes a portion of the bill that would have struck certain language relating to insurance carriers. The provision says that carriers are not required to cover certain services and treatment done by massage therapists. And there was concern on that, and stakeholders agreed that that provision should not be struck from law. So we're just removing all references to it from the bill so that the provision will stay in law and it will still be optional for carriers. And it will be clear that it is optional for carriers to provide these services or not.
And just to be clear, the intention was not to change the insurance law, but we're just doing this out of an abundance of caution. So with that, I'm going to move the amendment. Second. Perfect. Any discussion on the amendment from the subcommittee? I'm in the waiting room. I see so many people there. Hold on. I don't see any. So all in favor, say aye. Anyone who's opposed, go ahead and raise your hand in the side there. I don't see anybody. Sorry, it's very hard for me, my participants list. There's so many people today. Let me try again. Okay, so the bill as amended, move the bill as amended. Do we have a second?
Second.
Awesome. All in favor, say aye. Anyone who's opposed, raise your hand. I'm going to say that bill passes. I can't find the hands because everything's all messed up here in my side, so I apologize. There we go. Okay, in the meeting. So it passes unanimously. Number 2 is going to be the licensing of audiology assistance bill, Senate Bill 379, which needs an amendment as well. Tyler.
Senate Bill 379 has purely technical amendments coming in. The original amendment missed a couple references to registered that were being changed to licensed throughout the bill. That's page 6 of the PDF packet, and a reference where the amendment changed the term to licensure, and it should have changed it to license. So it's just technical fixes for Senate Bill 379. It is otherwise identical to how the House passed the bill.
Move the amendments. Perfect. Moved and seconded. Any discussion on the amendments? Raise your hand. I'm seeing none. All in favor, say aye. Anyone who's opposed, raise your hands. Amendments passed unanimously on the bill as amended.
Move the bill as amended. Second.
Awesome. Any discussion? None. All in favor, say aye. Anyone who's opposed, raise your hands. Seeing no opposition, it looks like it passes unanimously. Perfect. The third bill we're going to discuss today is the Interstate Occupational Therapy Licensure Compact, Senator Carosa's Senate Bill 139. Tyler.
Senate Bill 139 is effectively identical to how 540 as it was passed. They did catch a couple typos in the bill, just missing apostrophes that weren't there in the version we sent over. So they fixed that. And so this is otherwise identical. There are no amendments to be offered since the Senate caught it before they moved the bill over to us on Senate.
So we have no amendment on this at all. It's just
no amendment. Yep.
Okay, perfect. So everybody loved this bill. I'll remind you, we passed it unanimously. All in favor, say aye. Anyone who's opposed, raise your hand. Seeing none, passes unanimously. Number 4 on our agenda is the other audiologists, hearing aid dispensers, and speech language pathologists bill, duties, etc. Senate Bill 523. Tyler.
Senate Bill 523 is cross-filed with House Bill 600, and this just a summary of the bill gives a couple of updates and revisions to the article, or rather the title. But in this case, the Senate bill didn't completely conform to the amendments that the House made to HB 600 before it moved. So this amendment conforms the bill to HB 600 as it passed the committee and House unanimously. And that's page 9 of the packet.
So we're conforming the Senate bill to the House version.
Correct.
And moved, and do we have a second?
Second.
Any further discussion on this bill? I see none. All in favor, say aye. Anyone who's opposed, raise your hands. Looks like we all support conforming it to the House bill. Great job. Senate Bill 523 passes unanimously. Number 5. Yes, Senate Bill 507. I think we might be moving into Lisa bills now. Senate Bill 507, Division of Consumer Protection, Assisted Living.
So this is a cross-file to House Bill 554. The Senate put a slightly different amendment on it than the House version. Their amendment did that was different from ours was requiring the Office of Healthcare Quality to notify the division of the appointment of an assisted living program as a resident's representative payee within a reasonable time after being made aware of the appointment. And then now that they have the House bill, they tweaked that language a little bit. So there is an amendment in your packet on page 8 that just clarifies that requirement. So if we accept that amendment and pass the bill this way, it will match how the cross file is coming out of the Senate. And the sponsor, which is the vice chair, is okay with that amendment.
And can you just explain to us again what the amendment exactly does so that the committee knows?
It requires the Office of Healthcare Quality to notify the Consumer Protection Division of the Office of the Attorney General of the appointment of an assisted living program as a resident's representative payee within a reasonable time after being made aware of the appointment.
Okay, seems reasonable to me. Any questions from the committee? Okay, seeing none.
Delegate Collison.
Sorry, I can't find my raised hand.
That's okay, speak up.
So we're putting the burden on, and I'm okay with this, I'm just clarifying. We're putting the burden on OHCQ to make the notification, period.
If they have notice of it, then they are required to tell the Attorney General's office.
Okay.
They have notice.
Okay.
Within a reasonable time, right? Okay, delegate.
Yes.
And how does the resident or the person know that they have this right or they have this ability to do this? How are they notified?
How is the
The person.
The resident can choose whether or not they want to have the assisted living program be their representative.
So they're given like option. They're given the options to know that.
Yes.
What's available. Okay, I just want to make sure they have a way of knowing what's and choices they can make.
They would have to proactively make this choice, right? Right, Lisa?
Yes.
How do they even know that the choice exists? I mean, are they given a pamphlet or something? How do they know?
I'm sorry, I don't really know the answer.
I mean,
Eric
I'll look at it later, but we got to make sure that people that are in the situation know that they have this opportunity to complain. But getting that information out, maybe the Attorney General's office can do.
Okay, so with that, we need to adopt the amendment, right? So,
Move the amendment.
okay, moved and seconded. All in favor of the amendment, say aye. Anyone who's opposed, raise your hand. Okay, seeing none, the amendment passed unanimously. On the bill as amended.
Move the bill as amended.
We have a lot of bills to move today. We can all take turns. Anyone who's opposed, raise your hand. Everyone who's in favor, say aye. Passes unanimously. Delegate Krebs, we have a day or two to learn a little bit more about that, but I think we'll be comfortable with it. Okay, number 6, public health long-term care planning. Senator Klausmeier, Senate Bill 652, also a Lisa bill.
Yes, and this was a cross-file to your bill, Delegate Kelly. The Senate just added another amendment that requires that the material that they're publishing on long-term care planning is understandable to individuals with limited literacy skills. So there are no amendments on this bill. I was just explaining the difference between the two cross files, and they're amending. We actually even have the concurrence, Delegate Kelly, for your bill. So at the next voting session, we'll be.
Perfect. So we're going to concur with their amendment that requires that it be easily understandable, which I think is reasonable. Any questions from the committee on that? Delegate Krebs.
Thank you. I mean, we have a letter in here from the Department of Health, basically saying because of COVID response efforts, they do not have any fiscal or personnel resources to implement the bill if passed. So do we change the date for this to occur? I mean, they're swamped with COVID right now, so it's going to be interesting. I mean, you're asking somebody to do something they just basically said they don't have the time to do. So did we change the date?
The date right now is April 1st, 2022. Yeah,
I mean, I'm voting against it because I really believe that this just is not necessary right now. With the Department of Health is working trillions of hours trying to deal with COVID, and I don't see that ending anytime soon. And once it does end, those people are going to need a little bit of a break. So just the mere fact that I don't think it's possible to do, and they've stated that, I think it's unreasonable. But
I see that Joan Smith is in here. Did you want to say something about the timelines in this bill in response to that? Because I know it was bumped out.
Yes, we knew that they were dealing with COVID and we were sensitive to that. And so we did bump the timeline up, and we thought we did not hear from them. We didn't hear any opposition from any of the departments about this. So I wasn't aware of the letter that she's referring to.
I think we got that letter on pretty much anything.
it's in testimony on this bill. It's in our packet.
Delegate Bandari.
Yeah, thank you, Madam Chair. Eric, do you want to say anything? I've seen your letter there, right? Was it on this bill?
Thank you so much. Madam Chair, is it all right if I speak?
Sure.
Yeah, I'm not sure that I was going to say much, except that I think that this is a really great bill that the chair and Senator Klossmeyer has put forward. I understand the limitations on the department. I've seen a similar letter from them about delaying legislation in a number of different areas. Certainly, the subcommittee respect whatever you decide, but I do think that this is a really important effort that would not take up that much bandwidth of the department. So I thank the chair for putting it forward.
Okay, and I will say that we already passed the cross file to this one. So, your vote is your own. Feel free to vote however you want, but I think we're okay with calling a vote on it. So does somebody want to move the bill?
Move the bill.
Moved and seconded. Everyone who's in favor, say aye. And if you want to be noted as in opposition to the long-term care planning, we will raise your hand and we will note it. So I see Delegate Krebs. And it looks like that is it. Okay, thank you. Number 7 on our agenda today is, State Board of Social Work Examiners, temporary license to practice social work. I think we do have some stakeholders here on this bill that we definitely want to involve in the conversation. This is also a Lisa bill. So why don't you, as we let the stakeholders in, Lisa, remind us what the bill does.
The bill authorizes the State Board of Social Work Examiners to issue a temporary license to an applicant who, except for passing the required examination, has otherwise completed the appropriate education and experience required for a license to practice bachelor social work or master social work. A temporary license is valid until the earlier of notification of permanent licensure or 1 year after the date on which the temporary license was issued, and there are no amendments.
Okay, and do we have anybody here? This was a bit of a contentious hearing. I think, do we have anybody here who wants to speak on this bill? I'm not seeing any hands. But, go ahead, Rachel.
Rachel.
Hi, Rachel Faulkner here with the National Association of Social Workers. And I think Daphne McClellan either is here or maybe still in the waiting room. I would just say that this bill, we know that the board had some opposition. This board does not require, or this bill doesn't require the board to issue temporary licensure. It just gives them the authority to create a temporary licensure process if they choose. It also, their title already has existing provisions that allows them to promulgate regulations for their title. And so they already have the authority, if this bill were to pass, to address any of their concerns that they have, creating additional parameters or provisions around how a temporary licensure process would work through their existing regulatory process. In addition, after meeting with them earlier this year with the Senate sponsor, there was an amendment added to restrict this to only 2 licensure categories that already require board-approved supervision. So there's that safeguard in place as well. And you'll also see in the written testimony that there's a lot of information about other states that offer temporary licensure to social work applicants, as well as some boards in this state that have some category of temporary licensure based on their professional requirements, including we modeled this after the existing temporary licensure process for occupational therapists. And I know Daphne can mention, just anecdotally, we are still hearing that applicants are having a difficult time finding testing slots, even a year after COVID has started.
Daphne, do you have anything to add?
No, I know that the Board of Social Work Examiners has said, that they are concerned about people who might not have passed the test or being unleashed on the public. But I do think that, there are other states that do have temporary licensing just as a matter of course within their law, such as big states like New York. They have a temporary license for a year. Texas. So there are other states that have many, many more social workers that are getting licensed immediately. Those people are given multiple opportunities to pass the test during the time of the temporary license. I know usually when a person has not passed the exam, because I know that is really one of the things that they, focused on in the committee testimony. And when they often it's by 1 point or 2 points that, it's not like, people are in the basement on their scores on these exams. I'm also not a person who believes that an exam is the be all and end all of whether a person can be a good practitioner. But I'm not saying that exams aren't important, but I do believe that we're talking about emergency situations. We're not talking about always. I don't really know the explanation for why there were such a number of people who didn't pass it this past year when it was given. But I have a feeling that there's a lot of anxiety, during COVID. Many people had to travel for hours to get to the place where they were allowed to take the exam this past year. So I think, that should not be the primary concern. I think this makes total sense to have this emergency situation of this possibility available to people in an emergency situation.
Thank you. Before we go to Delegate Cullison's question, I want to see if there's anybody here from the board. I have such a long participants list. I don't see anyone though, but speak up if you're here from the board to talk about this.
And in the waiting room?
I'm not seeing him. Hear from
Stan
anybody?
or Jerry?
He's not here. He was invited, but he's not here.
Okay.
Okay, well, let's hear from Delegate Cullison.
So I want to just be really super clear. Number one, super clear, would apply only in emergency situations, correct? The way the bill is now?
Yes,
Okay.
absolutely.
And that it only applies to licenses which have which are continue to require supervision.
Right. It would be for the LBSW and the LMSW, which are the entry-level licenses, and those people are required to only practice under board-approved supervisors.
Okay. And the board members will be, should they elect to define this process, would really make the rules around who qualifies and what they would have had to have, what they would have had to complete in order to be eligible for this temporary license, right?
Right. They write the regulations. Mhm.
Okay. I'm wondering though about the year. It feels a little long to me. I think and maybe it could be renewable, but I'm wondering what a 6-month period would feel like, and with the possibility of renewal if the circumstances warrant it.
In the states that already have this, it runs anywhere from 3 months to a year. And those that have less than a year do usually have a provision that it's renewable one time or something like that. So whatever you think is best, delegate, I'm certain that would be fine.
I'm just thinking that might sort of assuage some of the concern around, having somebody with a temporary license, who could potentially not even take the test at all in that year. Whereas if it were 6 months, that would sort of be an incentive to make sure you take the test and get all final certificate requirements of a certification.
Yeah, I would say my only concern is, right now this emergency has already gone a year, so it really depends on the situation why the test isn't available. So last year, there were several months when the test wasn't available at all. All those Pearson VUE testing centers were closed down. And then they sort of came around and they were able to reopen them, but they were reopened with social distancing. And so there were fewer test slots because they just couldn't get as many people in there at a time. So what we're finding even today.
Can I pause this conversation for a second? Because I just got a text from Stan, who's trying to get in. He has a lot to say. But he can't seem to get in. The link isn't working. So let me make sure that Sharon from my staff, can you resend Stan a link so that we can make sure it's here for this conversation?
I have. I'm still not
now
in the waiting room though.
We don't see him in the waiting room. Okay. Yeah, I don't see him in the waiting room either. I definitely don't want to have this conversation without him because obviously, it's his concerns that we're trying to address. So why don't we put a pause on this bill? It sounds like Delegate Cullison, you're proposing an amendment in concept that would do maybe 6 months, perhaps renewable at least once. Is that what I'm hearing from you, Delegate Cullison?
That's kind of where I'm going. And I think that renewable piece would get to the concern about the tests not being available. That would be a condition under which it should be able to renew.
Thank
you.
Okay,
so Delegate Krebs, I know you have a question, but let's hold on to it until we can get Mr. Weinstein into the room. So we will pick up this conversation as soon as we get him inside. But it sounds like we're sort of discussing potentially amending this bill. Let's move on to, okay, we can talk about Senate Bill 298, which is also a Lisa bill, State Board of Pharmacy closure notice to customers. Lisa.
So this bill specifies the customer notification procedures the owner of a pharmacy must follow prior to closing a pharmacy for more than 7 consecutive days. The pharmacy owner must either at least 30 days before the anticipated closing, post a specified notice in the pharmacy and on the pharmacy's website, and provide written and verbal notice to each client who picks up a prescription or refill, or at least 14 days before the anticipated closing, mail a notice to each customer that has a current and authorized refill of a prescription on file with the pharmacy. The bill specifies what should be included in the notices, and the State Board of Pharmacy must adopt regulations to define closing of pharmacy and provide exceptions. And there were no amendments.
Okay, and this is a bill we came over from the Senate. We didn't have a House crossfile on this, so it's new to us. I know Delegate Krebs had a question in the hearing. Does the committee want to have a discussion on this bill? How are we feeling about it? Anybody? Strong feelings? Anybody want to move the bill?
Move the bill.
Delegate Krebs has a question, so we'll discuss it. It's been moved and seconded, but Delegate Krebs, go ahead.
Yeah, we had a question about changing the time frame. Lisa, what did you say the time frame was again? It's still 10 day?
It's not 10 days. This is at least 6 days before the anticipated closing. Post a specified notice in the pharmacy and on the pharmacy's website, and provide written and verbal notice to each client who picks up a prescription or refill, or at least 14 days before the anticipated closing, mail a notice to each customer that has a current and authorized refill of a prescription on file at the pharmacy.
I think that there was some talk about the mailing notice option. And who's going to do it? Specify that any mailing notice is done by the acquiring pharmacy, because the person out of business they're selling. I mean, who is responsible for doing the mailing?
Pharmacy that's closing.
Yeah, I think
It's a burden, potentially a burden on them.
I think it's potentially a burden, just considering it might be an emergency they've sold, or I mean, I don't know, but it seems like there could be either or. The mailing option just seems a lot. I mean, you could have hundreds and hundreds of people, and something could happen quickly. I just concern of mine. Maybe we could hold it and talk to the sponsor if they wouldn't mind that. I mean, I didn't have time to get the amendment made up. It's not a high priority, but I just think it's a burden on the facility.
So do you want to come back to this bill at our next meeting and see if you can work up an amendment based on that letter?
Well, there were two suggestions for amendments. One was to eliminate the mailing notice option, or specify that the mailing notice can be done by the acquiring pharmacy. It could be either or, and then change the time limit for a posted notice from 30 days to 10 days.
Does the committee feel strongly that we need to keep the mailing notice, which may be a potential burden? Is anyone, Delegate Bandari?
I'm sorry, I have a question on other issues.
Go ahead. It's the
On
time.
the bill itself. Unfortunately, I think Dr. Stanley is not here. There are the issues temporary license expire, and they do have a.
Yeah, we held that bill. We're going to wait until we get
Okay.
Dr. Weinstein in the room. So we're working on getting him in the room. So now we're discussing the pharmacy closure notice bill. So Delegate Krebs is looking at the letter, suggesting some amendments. The amendment suggestion was that we either eliminate the mailing requirement or put that burden on the acquired pharmacy because it may be a unnecessary burden on a business.
Well, Delegate Kelly, though, just to be clear, there's two options. They don't have to choose the mailing option. They can choose the other option.
Of shortening the notice.
Well, they can choose to do at least 30 days before the closing, post a specified notice in the pharmacy.
So the mailing is an option, but they could also post a notice, which is less burdensome.
Correct. It's just that says at least 30 days. So I guess you would have to have 30 days to do that. And if you don't have the 30 days notice, then your other option is the 14 days notice.
Or we could amend it to say 20 days or 14 days for a posted notice also is a possibility. Delegate Bagnall.
I sort of echo Delegate Krebs' concern about it being burdensome, and I do understand that we have the either or option, but I think Senator Riley, when he testified, talked about that it was a very rapid closure. So would it be possible to do something like 30 days if practicable, but no less than 14 days or no less than
Posted notice. I think that's a really good idea.
because that would give clarity that the intention is, if possible, to give as much notice as possible, but that there may be occasions, emergency occasions, in which that 30 days is not reasonable, and we don't want the pharmacy to then be penalized again for a closure.
Right. So what you're suggesting is that we address the concern by giving a 14-day option if it's not practicable to do 30 days.
Yeah, if that's reasonable.
Yeah, I think that sounds reasonable. Delegate Krebs, does that make sense to you?
I think so. I'm trying to, I mean, sometimes it's not a good situation when someone has to close down and they're doing a lot of other things. And I'm just reading this and it says posting a notice that is conspicuous position in the pharmacy and readable by pharmacy customers. And if applicable on the pharmacy's website, and providing written and verbal notice to each customer who picks up the prescription or at least 14 days. I mean, I'm not sure. There's a lot in this. It just seems a little, I mean, just eliminating the mailing. I'm not sure if we each notice.
So it sounds like you need a little bit of time to take a look at this, and Stan is here now, so that's good. So let's go to that conversation. We will try and pick this up at the end of the agenda to see if we can move
Okay,
out today, because we're getting close to sine die, potentially with Delegate Bagnell's proposed amendment, which I think is a nice compromise. But we'll put a pin in this for now and go back to the social work examiners bill. Stan, do we have you in the meeting now?
He's connecting.
He's connecting. Excellent. And if we, while we're waiting for him to connect, let me ask Lisa, if we were to propose an amendment similar to what Delegate Cullison is suggesting, could we vote on that in concept and get around to actually drafting the amendment? Is it simple enough that we could do that so that we could keep this moving? Or
I can draft it by the time you're in full committee, if that's what you're.
yeah, exactly. I mean, it's a simple enough amendment, I think, for the committee to understand. We could vote on it in concept, and then by full committee voting session, we would have the language to look at.
Mhm.
Perfect. Okay, so Stan, are you here now? Oh, he's so close. I see the connecting dots. He's slowly, but not so surely connecting. I wonder if there's Delegate Saab.
Just have a quick question, and I don't remember if I asked the senator, but why is it the Dennis Robin Act? What was the reason for that?
He did tell us in the hearing it was named after
It was named after the constituent who showed up to pick up his prescription and found out it was closed, I think.
Do we still have a habit of naming bills after people? I thought this was like a one-time thing that we did before with other bills.
Well, we certainly didn't put the name on. I don't know, Lisa, if we have a habit of striking a name if it comes over from the.
We can. I don't.
I've never seen that situation arise before.
I'm not suggesting, I'm just trying to be consistent with what the.
No,
committee
I
has
appreciate it.
done.
Our policy is still, we're not going to add it on except for those few rare occasions when we break our.
Right.
Yeah. Okay. Unfortunately, Stanley's iPhone is still having difficulty connecting. Nope, still connecting. Let's move on to, oh, this could take us a while. The House Bill 652. Hopefully it doesn't take us a while because we have discussed this. I think this is the fourth week. I would really like to vote on this week, guys. It's not fair to keep dragging it out. So House Bill 652, which is the Residential Service Agency's Guidance and Reporting Bill. If you remember, we held it last week because Delegate Krebs wanted to take a look at the letter from the Department of Health. I believe this could take us a while. Oh, I'm echoing. I believe that we're gonna, sorry, we're not gonna hear anything different from the Department of Health. I haven't. Delegate Krebs, did you get an update from the Department of Health on whether they feel like doing this or not, or their position is still the same as the letters we've been getting on all the bills, sort of leave us alone?
isn't this the one we just did?
This is the bill that you held last week that had to do with the residential service agencies and the classification of employees. And we had struck the reporting and put in, it's just a guidance document that's being developed by the OAG. And then a very streamlined checkbox on that.
Delegate Krebs, I think there's some confusion because we have a Senate Bill 652 that we just did a few
No,
minutes. And then there's also House Bill 652, which is
Okay, that's what's confusing me. So the Senate.
Thank you, Lisa.
Okay, I am confused about it. Because they're both listed as Senate Bill 652 on this chat. That's why I'm very. Okay, so on the chat, it says 650. So I don't even know the one that I just voted on. I thought this one, because they both were Senate, they're both listed as Senate Bill 652 on that.
Oh, that makes perfect sense. Okay, that makes perfect sense too, because
That's why I'm confused.
they're on that bill. So do you want to change your vote? You were the only outlier on the
Well,
long.
what was the bill? I mean, what was that
It was
bill?
a long-term planning bill that also, it has the Department of Health coming up with a planning or a document to give to individuals, telling them about their different long-term planning options.
Okay, that's fine. That's what I'm confused about because that was the, okay.
That's the bill
Okay,
we
that
were
makes
talking
sense.
about before.
Okay, good.
So
this
we'll
is House
make
Bill
that a
650.
unanimous. So Senate Bill 652 will go back to being unanimous, but House Bill 652, you are concerned about the letter from the Department of Health. So you are going to vote no on.
Well, and I'm not just concerned about that. I think we've changed it, and at least correct me if I'm wrong. Now we've got it that the attorney, the consultation with the department and the Department of Labor, the Attorney General. I think I mentioned this in the hearing. I was a little frustrated because the Attorney General's letter basically says many of the employees at RSAs, notably personal care aides, are misclassed as independent contractors. And I was very shocked that they have made it, they haven't even done the study yet, and they're already telling us that they're misclassed. And I don't know where they got that from. They've already made their determination that there's misclassification. So it seems like they're going into it with a preconceived notion about their misclassification, but
So on this bill, let me just full disclosure to the committee. The amendments that we adopted last week had some, I don't know if you could classify them as technical or non-technical, but we unintentionally had the checkbox apply to the entire group of RSAs as opposed to just those that use Medicaid. So we have to re-adopt the amendments so that the checkbox applies just to the Medicaid RSAs. So if we want to move this bill, we have to re-adopt the amendments and then we can take a vote on the bill. And I think it is at this point understandable that there may be some philosophical objections to the bill. I have tried so hard to work on this bill so that it was palatable to everyone. I think that everyone recognizes, it's changed a lot since it came in. We're not trying to make a predetermination that this is misclassification. The stakeholders are all in somewhat reluctant, but nonetheless agreement on these amendments. So to the extent that can give people comfort, that's great. But if you're not going to be able to vote for this simply because it deals with the issue of employee classification, that's understandable. I think the reporting will be a useful tool for us. I think particularly the reporting on the overall reimbursement rate will be a very helpful tool for us. So I think it's time that we just re-adopt the amendments and take a vote on this bill because I don't think we're going to ever reach full consensus.
Madam Chair, I want to thank you. I think the bill has gotten a lot better. I had experience a number of years ago with the Department of Labor for another whole issue, and it was very interesting how, and I'm an accountant, and I know what this issue is. I know it very, very well, contractors versus employees. And the way that they interpreted it a number of years ago, they were changing their interpretation because they wanted more people to pay into unemployment. And it was really very frustrating to me. So I had a bad experience with this misclass and a former administration trying to use it to bring up their unemployment coffers. And that's why there's a lot of gray area in this issue. And I just had a bad experience about it. And that's why I don't like the fact that the Attorney General has already made a decision about it and he's going to be writing it. But you've done a lot of good work on getting this to be more of a report. So I do appreciate that.
Well, thank you. I really appreciate that too. And again, we'll take this up in the fall and learn more about this as a committee from the Department of Labor and the Department of Health. But with that, I'm going to move the amendments again.
Second.
Excellent. Any further discussion on the amendments? Delegate Cullison? No. Okay. All in favor of the amendments, say aye. Anyone who's opposed? Okay. On the bill as amended.
Move the bill.
Second.
Okay. Any further discussion on this bill? Thank you, guys. All in favor, say aye. If you're going to vote no, go ahead and raise your hand in the side. I see Delegate Saab is a no. I see Delegate Riley is a no. I see Delegate Krebs is a no. Okay. I think that's it. Okay, so it passes, but not unanimously. Thank you, everybody, for the constructive work on this all session. And it'll be an issue we'll be discussing again next year. It sounds like Stan is potentially back with us. It says he's muted, but I think that's on his side. Can anybody see Stan?
There he is.
Can you hear me?
Yes, we can hear you. Great news. Okay, so we are going to go back to the Social Work Examiner's Temporary License Bill, which is Senate Bill 167.
Can I thank you for your
I think
patience?
Delegate Krebs has a question. Delegate Krebs, can we hold your question until we hear from Stan since he worked so hard to get in? Okay, go ahead.
First, let me thank you all for your patience in the lack of either my technology or my computer's ability, but I'm on my phone and I'll be glad to answer any questions or be of assistance.
Okay, Delegate Krebs, did you have a question on this bill?
Well, I wanted to hear from Stan because Stan, your testimony was very interesting to me and very, I mean, I think your testimony was excellent. And I just wanted maybe to give you the opportunity to reiterate why the board does not believe that they need the ability to have these temporary licenses and the problems that are involved. And it was in your testimony, I've highlighted it, but you might want to remind our committee what that opposition was.
Thank you very much. The Board of Social Work Examiners understands the plight of the students who were caught up in the pandemic and the delay in testing, but the board exists to protect the public. And like the Board of Medicine or Board of Physicians, Board of Nursing, the Bar Association, the Board of Psychology, nobody wants a temporary license where you take away the exam that measures minimum competence, knowledge, skill, safety, and ethics. And the board feels strongly, it was a unanimous vote all through this, that they feel this is not the best way to protect the public. And then if it does pass, the implementation of this would be very difficult for the board. There are no standards for what is acceptable as a reason to give a temporary license. It wouldn't be just for the pandemic. Once it's on the books, anyone could apply for any reason. There's no standards to say yes or no. And then once someone would have a temporary license, tracking it, monitoring it, and seeing that they don't practice when the year ends would be very challenging. And I think there's a liability that if you have someone who becomes unlicensed, but they continue to work for you, then you're liable for any problems that develop. We just feel this has so many unintended consequences. And the real thing is the public doesn't benefit. I gave numbers in previous testimony that if we had applied it to 2019, we would have had, I think, 381 applicants who would have been given a temporary license who would have statistically failed the exam. This is not in the best interest of the citizens of Maryland, and the board has been consistent in feeling this way.
All right, so that was Delegate Krebs's question. I see also Delegate Cullison has her hand up. Delegate Cullison.
Thank you, Madam Chair. Thank you, Stan. Thanks for first of all, for your patience and persistence in getting in. I guess I wanted to get a little more understanding. So it's my understanding from the bill that's written that it does only apply, that the eligibility to apply for a temporary license would only apply during a health emergency. Do you have a different understanding of that? And if so, maybe Lisa, you can help us clarify.
Well, no, and I don't know how a health emergency is defined unless it's the governor's executive order as he did in this. But even so, we still don't feel that the public benefits from this. I think we didn't know how long it would last with the testing this time. They shut down testing for a month, but by the time they got it back with safety precautions, if you track it through the rest of 2020, they tested more applicants in 2020 than they did in 2019. So we got it back, the testing company did. I think the risk, you have to weigh the risk. Is it the risk to the applicants who have to be delayed, at least it was in this instance, or the risk to the public?
So may I follow up? Madam Chair?
Sure, please.
So I hear you. So I wanted to follow up on another concern that you had in terms of liability. I guess I push back a little on the public doesn't benefit because, I've just spent almost the last 90 days dealing with a paucity of mental health workers. I mean, almost every bill that has come through HGO this session has some element of behavioral health, mental health, and, the lack of providers. So, so I would say anytime we can put providers in the field who have reached a level that we can feel relatively comfortable with, it would be eligible to apply for this. But in the case where you have a position that is supervised, does the supervisor assume the liability for and responsibility for monitoring that the supervisee and making sure that the service is meeting standards of care, so that we're not leaving the public with someone who is totally unsupervised and doing, that could be left to their own devices?
I think it's a good point, and I too would like more mental health people because the citizens need it. Social work is particularly important in this discussion because social workers provide the bulk of mental health services, not only in Maryland, but in the United States. The numbers are consistent. We have over 10,000 clinically licensed social workers, but we want ones who are competent. They're dealing with the mental illness, they're dealing with domestic violence, they're dealing with abused and neglected children. The supervisor does play an important role and assumes responsibility, but the supervision is not direct supervision. As I think there's been a bill for occupational therapy, a temporary license, I believe, if I'm correct, but they have direct supervision. The same way with nurses, they have a supervisor in the room observing. Social work, because we respect the confidentiality of the client or the patient, it's behind closed doors. And so the supervision occurs after the fact. Once a week, you'll meet with your supervisor and review cases, but the interaction has already taken place between you and the patient or the client. We just feel that there's risk in that. While we want social workers to provide mental health services, we want competent social workers who have met the minimum standards outlined by the profession that are recognized nationally. The same way, as I said, for my colleagues in other professions, they would not want a temporary license attached to their statute.
I guess, but I understand that nurses have it. And there was also, I think, occupational therapists. Am I right that occupational therapists have a temporary?
I think they do, but they have direct supervision. That's, I think, one of the differences, because the supervisor can be there observing at the same time.
I think
I'm
seeing Rachel shake her head, so she may have some clarity.
I'm sorry. I actually reached out to the Board of Occupational Therapists yesterday just to confirm what they had said to me last year when we looked at this issue. They do not require direct supervision with somebody being in the room for their temporary license. What they require is that the person be on site. So think about a large hospital system. Your supervisor could be in a completely different wing, somewhere else on campus. It doesn't necessarily mean that they're in the room when those services are being provided. If the board believes that that is something that they would like to replicate, they could easily do that through the regulatory process. I truly believe that the concerns that they have about practicing without a license, practicing after your license expires, all of the existing provisions that they have in regulations for licensed practitioners could be extended or adapted to address temporary licensure status. So, I think that there are really, there are existing ways that we see in other states and in Maryland to really address some of these concerns, including, what does supervision look different under a temporary license than it does otherwise? But these supervisors are already board approved.
So let me, before we go to Delegate Bandari's question, and we can go back to Delegate Cullison if she has more, I want to repeat something I heard you say before Stan joined the call, because I think I heard you say that you feel like the board has a lot of control over how this process would unfold through the regulatory process, and that most of their concerns can be addressed in that process. Did I hear you say that?
So the bill was specifically drafted to not include, I know the board is concerned that the bill doesn't include a lot of provisions, parameters around the process, and that was intentional to allow the board to be able to answer those questions themselves with stakeholder input through the regulatory process. So for instance, there actually isn't anything in the bill that says that this is limited to an emergency situation. But if the board wanted, they could draft regulations that says that they would only issue temporary licensure during a state declared public health emergency, when testing centers are actually closed for more than 2 weeks, and whatever they chose to do. And that was very purposeful so that it could be open or limited through that process. The bill never says the board shall issue a temporary license to anyone. It says that they may. And so we're not actually requiring them to issue temporary licensure in this bill. We're giving them the authority so that, last year when testing centers closed and students and colleges and the professional association went to the board and said, we need to do something. The testing centers are closed. Can we please issue temporary licensures? They came back and said, our statute doesn't allow us to do it. Our hands are tied. This bill would open the possibility to say something different in a future emergency.
And so in theory, if the board determined the only circumstances under which they wanted to issue a temporary licensure was when the sky turned green, I don't know of a public health reason why that would be the case, but just as an example, under this bill, they could do that.
Absolutely.
Okay, Delegate Bandari.
Yeah, thank you, Madam Chair. Thank you, Delegate Collison. C asked a lot of questions, but a couple of questions to Dr. Stanley, if I may, Madam Chair.
Sure.
In your letter, difficult experience by applicant who have waited the licensing examination. Do you want to comment on that? And how critical was the need during the pandemic? We know that we are not out of the pandemic as well. And we are talking about here 381 applicants. And I would like to know how critical was the need. And this practice is there, of course, in other profession as well, like the temporary teaching licenses are being issued for highly the content need area. So there is a practice. And the final question would be, how do we monitor those licensed professional? We just trust them, or even everybody do? I know it is critical and confidentiality. You raised your point. It is done behind the closed office door. And don't we have some sort of supervision to those as well?
Yes, there is supervision, but it's supervision after the fact. Our concern is that the 381 would be just those who we would project would have failed the exam. There's a pass rate that is generally on average close to 80% pass, but that means 20% don't meet the standard for competence, skill, and ethical practice. And those are the ones that we would be concerned about, would be even in an emergency, and maybe even more so in an emergency, out serving the public. So the board has been consistent in saying this is not something that should be risked, is taking people who don't meet that minimum standard and putting them out there trying to serve the public. I hope I've answered your question.
You answered one question. How critical was the need during the pandemic? Because this bill is just for the emergency purposes for the future, and still we are not out of the pandemic.
Well, there's a tremendous need for mental health services. I think the pandemic has increased the need. I think many people have talked about, and there have been studies showing that the anxiety rate has gone up. We have suicide going up. So I think the mental health and emotional needs of the citizens has increased during the pandemic. But it's for those reasons that you want competent people who meet that minimum standard as the ones who are assessing suicide risk and other kinds of service needs. But the need is great. I don't want to minimize that.
Yeah, Dr. Stanley, if that would be my last question. And you said there is a need, and I believe these social workers went to school and they have some knowledge, skill, some sort of competence. They might not have a license though. If there is a need, and this bill is just for the health emergency, why you are in opposition?
Well, because part of getting a license is not only the degree. The degree means that you have the fundamental knowledge, but there's more to it. There's the skill, there's the safety, there's the ethical practice. That is measured by a national exam. It goes beyond just the basic knowledge. And so we expect that the applicant meet that minimum standard. And as I said, that's the same thing for most professions. Even though there are exceptions and people are looking at this, most do not want it. And if we look at the mental health field, it's psychiatry doesn't want it. It's nurse practitioners do not want it. These are specialists in mental health. Psychology doesn't want it. Psychology has a temporary license proposed, but it's only for those who've been licensed actively in another state. So they're not interested. So in the mental health arena, there's, I think, consistent voice of no temporary license.
Let's hear from Delegate Bagnell, then Krebs, then Cullison. Delegate Bagnell.
Thank you, Madam Chair. And my question is for Dr. Stanley. Has the board taken any action to ensure that there would be no disruption to testing in a future emergency?
Well, we track it. And I think the reality is we've been testing for 45 years, and this was the first time. And the pandemic, I think, threw everybody, and it threw the testing companies because they weren't geared up with safe distance, social distancing, and mask requirements. And I think in terms of safety, they shut down. And they shut down not just for social work, but a number of other professions that this testing company does. I think they've learned. I think I've been in touch with the National Association of State Boards, and they say right now they are following safety guidelines, but able to handle the number of applicants that are coming in. So I think this has been a learning experience for all of us. I think all of us have had to learn the hard way through a pandemic. So I would see that they would have options available, and closing down the testing sites is not something they wanted to do, but felt it was the safe thing to do. But since then, they have been finding new sites and still maintaining the safety standards. So we don't think it will be an ongoing problem the way it was this year.
And I appreciate that. I mean, we were all caught off guard. And I think that is, speaking to this bill, it's attempting to learn from the experience we just went through and put a safeguard in place so that we don't end up with a future disruption. So I'm just wondering what steps we've taken on the testing side to ensure that if we have a future emergency, we don't have a disruption in the education and licensure of our health professionals.
I can't say for sure, but I believe that the learning has extended to making plans for contingency if something like this were to happen again. I have talked to the National Association. They feel as if we're on track. I can try and get more information from the testing company, but I think there's sort of an unknown. The reality is that none of us know how this is going to be going forward.
Absolutely. Thank you very much, Madam Chair.
Absolutely. So we have Delegate Krebs and Delegate Collison. Before we go to Delegate Krebs, I have a question too, because I'm baffled based on Delegate Bagnall's question. It seems to me that we could take that the board could take a two-tiered approach, right? If our goal is to make sure that people have access to this licensing exam, so that we're not in need of using temporary licenses, we can work really hard to make sure that they have access to that exam and set very narrow regulatory parameters that say, you know, this would only be triggered in the instance of the exam not being available and a public health emergency, et cetera, et cetera. You know, that's sort of where my head is. It's not really a question. Let's go to Delegate Krebs's question.
Thank you. So the way I understand this, Stan, if what happened in 2019 was replicated in 2020, if 381 people literally did not pass the exam, all of those people could have applied for a temporary exam and been working. And the way I read this, the temporary license is valid to the earlier of notification of a permanent license or 1 year after the date. So in other words, they can do this for a year, no matter, even if that test was only not available for 1 month. And I think that was stated, the test was 1 month not available. And after that, it was available.
Yes.
Although before we go to that question, let me remind Stan, because he wasn't here for that part of the conversation, that Delegate Collison was suggesting we amend that to be a 6-month period. Go ahead, Stan.
Oh,
But
thank you.
anyway, I guess what I'm trying to envision is these 381 people, if it was the same amount as in 2018 who failed, they could have applied for temporary licenses, and the way the bill's written, they could have just continued to practice for a year or 6 months or whatever. And you would not have any way to compel them to take the test. And I am assuming that these people have been working remotely. So they're working with their people on Zoom or something. So there's no way to ever be able to supervise them because I mean, you're on Zoom. It's not like they can, I guess, after the fact. So is there, in this bill, is there any way to compel these people if it was only out for a month in the testing? How do you compel them to go back and take the test if they've got a year to have this temporary license?
I don't know the answer to how to compel. And I think there's some risk of when the year ends, even to how do we track it and make sure that they're not working anymore until they take the test. I don't know the answer.
And then you also the other question.
I'm not sure if we lost
You
Delegate.
also mentioned that this year we had more people take the test and pass it in 2020, despite having this month off, than we had in 2019. So
Yes.
to catch up and get many people licensed or passing the, I guess, taking the test. Is that correct?
That's correct. That's what the National Association of Social Work Boards has informed me, that by the end of the year, they had actually, even with the month shutdown, tested more applicants than they did the year before.
Thank you.
Okay, we'll go to Delegate Collison, and then I'll remind the committee we still have the 3 dental bills and we don't have energy for too much contentious. So Delegate Collison.
Thank you, Madam Chair. I'm sorry to be a pain here.
No, this is an important bill. Go ahead.
So I guess in response to Delegate Krebs, I would say once the temporary license is expired, the supervisor would have to say either you take the exam so that you can be certified, so that you can be licensed, or you can't work for me anymore because I become liable for your services and you're now breaking the law and practicing without a license. So, I think that's how people would be compelled to take the test. Although I think if you are practicing under a temporary license, you're actually gaining skill. So the kinds of things that might be tested in the test, I think, beyond the ethical piece, which I think is more, rote kind of information and knowledge, but the actual practice is going to be built during the practice under the temporary license. So, because I think about other professions, I think I've heard that with lawyers, they actually practice law before they take the bar. So, and part of that is about, they're not called an official lawyer, but they're practicing and under supervision. So I guess I have one question for Stan and then one more question, and then, Madam Chair, however you want to move forward, is if the temporary if you're only eligible for the temporary license, if you have all of the necessary casework, training, and clinical practicum, and that it's only the test that's holding you up. I mean, can we accept that the test, you can retake it, but that you would have the opportunity to serve folks in a supervised setting, maybe not, I mean, however we want to characterize the supervision, but I guess, so my question is that the case? Before anyone could actually practice under a temporary license, they'd have to pass all the other requirements for being a social worker, other than just the test. Is that?
That is the way it is written, and but the test is it's just such an important part. It's really what is the other issues are criminal background checks, the degree. There is no experience requirement for the applicants we're talking about. That's why the supervision is so important. We have always had 2 years worth of supervision minimum following getting your initial license, because it is that important. But the basic requirements are the degree, the criminal background check, and the exam. So the exam is just very important. While we're talking directly, thank you for the change to the 6 months.
And what I was looking for is 6 months with the possibility of renewal under, under defined circumstances, whatever the board would decide those circumstances would be. So, because a year seemed like a long time for me. I can't speak for the committee, but it just seemed like a long time for me. Thank you, Madam Chair.
Absolutely. Delegate Riley.
And thank you, Madam Chair. I guess this question is for Stan as well. I do think that the 381 is a significant number that failed the test, and the thought that they were out there practicing is a little scary. And you said on a normal basis, did you say generally it is 20%?
Yes, it's a little more, sometimes a little less, but we seem to average around 80%.
Okay, well, I'm not, obviously I'm not familiar with how the test is set up. Is there any way that we know what, is it divided into sections? Is there a certain area that this 20% is failing in, or can it be divided divided up? And like laws, they have like 5 different tests you have to take, and same thing for CPAs. I'm not sure how this one is.
No, it's just the total
Just
test.
one.
And there are different sections, and some are stronger in one area or another. And I think the school should be concerned about the areas that their own student graduates may not do well in, but that has not been done. So,
Okay, so there's
at
not
this
one.
point, it's just total exam.
Okay, so there's not one particular area that we can tell at this point that they continue to fail and need additional work in or on?
No, not the way it's structured.
Okay, thank you.
Okay, before we go to
Thank you, Madam
Delegate
Chair.
Bandari's question, absolutely. Before we go to Delegate Bandari's question, I wanted to ask Daphne, because you had mentioned that other states do this. Do we have any knowledge on, I think you mentioned New York and California or Texas, I don't remember which 2 states, but
Right, so Connecticut.
my question is, do they have similar exam failure rates to Maryland? Is ours higher than theirs, or is it pretty much the same? And do they have a process for handling this?
I don't know what the exam failure rate is per state. I know that I contacted the Association of Social Work Boards, and it's 82% is the pass rate on the initial time a person takes the exam. And then, of course, people can take it again. So, I don't know how many of the 381 people who did not pass the test last year have had the opportunity to take it a second time, and what number of those. Normally people take it again and they pass it, but I do
But
know
Maryland's
that,
failure rate is about the national standard.
exactly.
Okay.
Yes.
Okay, Delegate Bhandari?
Thank you, Madam Chair. It seems to me that, yeah, the Senate voted this 47-0, unanimous. And I believe this bill will give an opportunity to future social worker to start work before the final exam. So I would like to move this bill with the Senate, Delegate Coalition Amendment.
Okay, so we have to move the amendment first. So that's, I guess, a motion on the amendment. Do we have a second on Delegate Collison's amendment?
A second.
Okay, so before we discuss the bill as a whole, let's see if we can the amendment. I see hands up. Delegate Krebs, did you want to discuss the amendment?
Yes, I mean, I wanted to hold the bill because I have a different amendment I'd like to offer.
Okay.
Okay.
So before we adopt Delegate Collison's amendment, we will, now I will say that thinking of the timeline for this bill, and this is not meant to, I'm comfortable with holding it because I want the committee to be comfortable with it, but if we're going to change it, we need it to have time for the Senate to concur. So we may also have to meet on Monday on the dental bills anyway, but we may have to squeeze in an extra meting. So Delegate Krebs, if you have a new amendment to consider.
Well, my amendment is similar to Delegate Collison's, but it's a little tighter. I just don't think that we have a problem as big as to solve that. We had a month period that we didn't have. So I would like to say until the emergency for the test is over. So it was a month this time. We could have had this for a month, but this 6-month thing, 1 year, I don't see why we need it. So I'd like to look at some language that would really get to what the problem was. Because right now it was a month problem. And
so you would trigger it in terms of access to the test as opposed to a finite time period.
It'd be much tighter. I just don't see that this is I always say, what's the problem we're trying to solve? I don't think this is as big of a problem as has been led to believe that it is. And I think we're causing more problem by what we're trying to solve. So I'd like to tighten that up. It was a month and we need to do with the testing and availability. With new testing, it's not going to be a problem at all because testing there's new ways of doing testing that you can do it remotely and tell if somebody is in the room. So I think there's great strides in testing. So I'd like to tighten this thing up. So it just can't be 6 months or a year or whatever, because I think it's problematic for the board to enforce it. And I don't want people out there that aren't qualified.
Okay, let's hear from Delegate Collison and then Delegate Bagnall, and then we'll move on to dental.
Since we're holding it, thank you, Madam Chair. Since we're holding it, I would like a little clarity, and perhaps we can get this from Stan or the advocates around, is it really only a month impact? Because I'm hearing that folks are still having to wait to take the test. So, and I keep hearing that there was only a month when it wasn't offered. So I guess I'm asking, can we get more clarity around how many people are waiting to take the test? How long are they having to wait now? So that we can, and that would include retesting as well. Because if you don't pass the test the first time, you need to be retested. So if folks can get us that information before we come back on, it would be really helpful. Thanks.
That would be great. Delegate Bagnall.
Delegate Collison and I share a brain. I'm essentially going to ask
Happy
the same
to
thing.
do so.
Okay, so when we come back to our next meeting, hopefully we'll know a little bit more about the problem that we're trying to solve and find the best way to move forward solving it. Thank you, team. Okay, let's do 1030, which is the dental bill. We need to let some stakeholders in. Well, we have 3 dental bills to discuss. I will remind the committee, we had the hearing on one of them yesterday. We're going to discuss that one, which is 836 LAM. We're going to discuss that in conjunction with Delegate Krebs's bill. We're going to want to talk about specific language for what could go into a work group, a report from the dental board. I don't think we're going to have time to really nail down what that language needs to be specifically today, although maybe I'll be pleasantly surprised. But I do think that we're going to be able to vote on 1030, which is Delegate Saab's bill that we've discussed, I think, for 2 weeks now. Tyler, can you remind us what that bill does?
House Bill 1030 would bring revisions to the process of nominating and appointing members to serve on the State Board of Dental Examiners. So for both the dental hygienist members and the licensed dentist members, the current process involves soliciting nominations from certain parties, including individual licensed dentists and certain organizations, and a balloting process to be conducted by the state board, and then forwarding at least exactly 4 times as many names as there are vacancies for the various positions. Delegate Saab's bill more closely aligns with how a lot of the other boards, I know particularly the Board of Physicians was looked at as a model for this, so that if enacted under HB 1030, the process would be that all organizations representing licensed dentists or licensed dental hygienists, at least 20, with at least 25 members or more in this state, would have the authority to nominate individuals, and then ballot nominations would go to the Secretary of Health and the governor for consideration. There would be no limits or cap or basements on the number of names to be sent to be considered for appointment, and it would remove the what I think fair to say universally considered expensive balloting process that doesn't actually influence the outcome per se, since it's always up to the governor's choice with the advice and consent of the Senate as to who would be appointed, regardless of vote totals or anything of that nature. So those would be the provisions of HB 1030. The other 2 bills are a different focus on the board.
Okay, super. So I'm going to remind the committee, we discussed extensively last week. I had a lot of questions and worked with the stakeholders to try and really nail down, is this exactly aligned with the Board of Physicians process? How is that working? I talked to the Board of Physicians. I talked to a lot of the stakeholders on this. I want to remind the members sort of where the different stakeholders are on this bill. The board has a support with amendments position. The amendments that they're requesting, I considered and I worked with the sponsor, talked through them, really thought about it. My concern about the amendments that the board is suggesting, the first one would extend the requirement to practice dentistry to 10 years from 5 years. Tyler did a lot of research and found no other board has a 10-year standard. So this would be pretty unprecedented. And my concern is that we have been struggling to make sure that this board has, diverse representation on it. And when you create a 10-year practice requirement, that's going to put us in the wrong direction. So I would be very reluctant to accept that amendment. And then the other thing that I thought was really compelling when I sat down and talked with members from the board, they were really looking for some assurance that the folks who get the appointment are in good standing. And I think that that's a reasonable request from the board. So I don't want to be pushing aside their request for that amendment, but it is more complicated than I think we can solve with this bill. That the other boards generally, including the Board of Physicians, do not have that language. I know there's interest among many of the boards for having that language. So in consultation with the chair, I think that what the best thing to do in terms of determining what does in good standing mean and how can we ensure that people serving across health occupations boards are in good standing is to have the same standard for all of those boards, and to really discuss over the interim with those boards what that should look like. So I think in concept, it's a really good idea, but in practice with this bill, I don't think that this is the right vehicle for including that. But I would make a commitment to really addressing that with all of the different boards over the interim so that we can figure out, from a policy perspective, what we would like to see to make sure that the folks serving on all of our health occupations boards, are qualified and, not there for the wrong reasons because they don't appreciate having been disciplined or something like that. So with that, after consulting with the sponsor, we actually decided not to include any amendments, but in the packet, and just see if we could get the support for this bill as it is. Again, I talked to the Board of Physicians. This really is exactly the process that they use. I think that there's benefit to taking the dental board out of this process. We all got a copy of their most recent report that was due to us in December, talking about staff vacancies and the challenges they face. I think it's appropriate, again, without the amendments that the board is looking for. And I know that the MSDA still prefers we keep the old process. I believe the hygienists are here. Caitlin McDonough's here. They are neutral on this bill. From what I understand, they have not used the election process for several years. It's we can hear from them if people are curious in the conversation. But with that, I'm going to move the bill as it is. Do we have a second? Anybody want to second it?
Second.
Okay, so I see Delegate Saab's hand is up and also Delegate Krebs' hand is up. Go ahead, Delegate Saab.
Well, I just want to thank Chairman, everyone else that worked hard, Tyler, everyone else working on the bill. I think this bill as it is, we did discuss the amendments that I'm just going to reiterate what you just said, but I think with this one, it will bring uniformity, and we look forward to have a new process that has been working for other boards, and I think it's important to move this bill. So thank you, Madam.
Absolutely. Delegate Krebs.
Thank you, Madam Chair. And I thank you. I think this bill is great as it is with no amendments, but I'd like to just add, there was a letter that came from Senator King to all of us we got today concerning some of the appointees that do not seem to be practiced dental hygiene.
So Delegate Krebs, if you don't mind, I really think that it's important. I read Senator King's letter too. I think that's good for the discussion of the next two bills because it's exactly those issues that we want to address in a report and a work group.
Okay.
We want to make sure that the folks who are on the board are qualified under the current law, as well as potentially changing those requirements. So let's discuss that after we vote on this bill, if you're okay with that.
No, I'm fine with it, but I just to mention they wanted to move it to 10 years. And we're trying to get people qualified with even the current timeline that we have, which is 5 years and 3 years for dental hygienists. So I thank you.
Another good point.
And I support the bill. Thank you.
Okay, so with that, all in favor of the bill, say aye, and anyone who wants to vote against it, go ahead and raise your hand. I don't see anyone voting against it, so it looks like this bill is going to pass unanimously. Thanks everyone for your hard work on this. So the next bill we're going to discuss is the bill we heard yesterday, which is Senate Bill 836. And we can have Tyler remind us what that does. And again, we want to think about this in light of House Bill 708, which is the bill that Delegate Krebs introduced that we've been discussing for a couple of weeks. There's a lot of overlap in these bills. And so what I would like to do is figure out how we can take Senate Bill 836, which right now is a task force, and turn it into some sort of report where we can get the information we need to move forward productively to support the board in their important work of dealing with disciplinary issues and really provide the structure that we need to get the answers we need. So Tyler, can you remind us about Senate Bill 836?
Of course, Senate Bill 836 has been printed for third reader, which is the form it comes to the subcommittee today. The bill establishes a task force to study and make recommendations regarding revisions to the disciplinary process and actions of the State Board of Dental Examiners that are necessary to improve the processes of disciplining dentists and disclosure of disciplinary actions. It provides for membership and the staff of it and other standard task force provisions such as compensation for travel, but not for the work, and a due date of December 1st, 2021.
And as I understand this, based on the current rules that the House is operating under, the no task force policy, what I think we need to do in order to make this passable in the House is turn it from a task force into a report, a mandated report. And so in the process of doing that, I think we should also look at what is being reported on, what's being and again, it can be a mandated report that is in consultation with all of the stakeholders. And it's very important that we have all the stakeholders who need to be there participating in this process. But I think the committee should take some time to figure out if there's anything in addition to what is written out already in Senator Bidle's bill that we would like to include. And we can hear from the stakeholders on that because I know we have a lot of stakeholders here. So I don't know if we have questions from the committee right away, or if we want to see if any of the stakeholders want to add any suggestions. Again, on the Senate bill, I believe the dental board is supportive of that as it came out of the Senate and willing to look at those issues. Do we have anyone from the dental board who wants to or Delegate Krebs? Go ahead, Delegate Krebs. Let's hear from you first.
Thank you. I think last week when we met, we had asked the board to provide a certain amount of information regarding cases that are in the process, not the specific cases, but just the timeline for cases And I don't know if they had time to get that together. I don't see it in my packet. But one of the things we'd like them to look at, and I have a whole list of information we like presented that has to go with due process. And, how are they handling due process, and is it really due process? And I have a whole list of it. I'm not going to sit here and ask for it all now, but I'd like to put it in writing and provide that along with our letter. And it basically has to do with just specifically what the due process is. We'd like the information on intent to summarily suspend licenses of providers, rescission orders, affirming. There's a whole bunch of things that we want to understand their process, that we don't believe that it's in a proper place right now. And maybe some of the folks that are here that have been experiencing this could speak to it, but I will give you this list of what we'd like to have in this in the timeline of how cases are handled and how efficiently they're handled.
Okay, yeah, I think that's a really good starting place. I don't know, I see Dr. G is here. I think I saw someone else also from the dental board.
Dr. Grant.
And then my question was, I don't know if they provided this information or not. I did not see it. I don't know if they had time to get it together, but that's the question.
Yeah, so let's hear from the dental board. I know that we had also asked for the Assistant Attorney General to be here. He couldn't be here today, but he was been very helpful in answering our questions in writing. So while he couldn't be here today, he's been very helpful, and I'm sure will continue to be so. Anyone from the dental board with anything to add to Delegate Krebs' question? Dr. G?
Yes, I certainly want to add comment to it. I think from the dental board standpoint, we support 836 moving forward. If not a task force, we understand that it maybe have to be a report. For Krebs, we do have a report from our sunset review that was provided, and you should have some of that information with you. We are able to speak to some timelines for you if you wish. And I know that Mr. Gerber, our OAG attorney liaison to the dental board, is more than happy to provide you with a litany of the standard procedures from the dental board. I was going to speak to some of the procedures in 708 when that comes up, just to give you an idea how that may work, if you wish. And so we can give you some idea of that process as well. The dental board, as you well know, and I've testified before regarding 836 in its original form, is not exactly the same as a physician's board because we're a different specialty and because we have practiced differently. There are some differences in how the two boards function, but in general, the alignment and the concept is the same. So yes, we're more than willing to work with whomever, Delegate Krebs or Senator Vital, who initiated 836 on the Senate side. We're looking forward to working with you. The board always looks forward to increasing its efficiency as well as its ability to function to protect the public.
Thank you for that. Do we have any more questions from the committee or any more, in addition to the due process language, is there anything else anybody from the committee would like to see added? Delegate Bandari.
Yes, since he's from the board, Dr. Arthur, yeah, I'm looking to your report on top 5 violation categories and complaint cases closed and average days of closed and open pending. While looking at the metrics, seems that the complaint went all the way down from 234 to 149. However, the open pending cases from fiscal year 2017, 27 to 113. Is there any rationale why it might have happened? And another thing, dentists are generally not affiliated with facilities that have disciplinary committees. So how big is that issue?
Well, if you're asking me if, in fact, the number of complaints have decreased over the last several years, the answer is yes. As you well know, that the dental board requires it to be a written, signed complaint to the dental board. And so the dental board has become, if you will, very rigid as far as having that occur as well. One of the issues that we're finding is a lot of the logistical issues. Obviously, COVID has come into play, but prior to COVID, we felt that, when there was a complaint and then trying to gather information, we found that there was a lot of changes in the subpoena process. So we would subpoena a person for a dental care, And we would find that perhaps that person no longer is a custodian of records because they work for a corporation. And therefore, we have to go through a rather elongated process to go to the custodian of records because that dentist may or may not be able to access themselves. The other process is that dental records include not only x-rays, but also cast models and all those issues that we have to get. And so that just prolongs that time from gathering the information in order to, if you will, evaluate the case, just to bring it to a certain level. Once that occurs, then it goes through the regular process that we have. But the processes are changing, and because of the ability for defendants, if you will, to appeal at every stage, we're finding that we're getting significantly more appeals in the process. So in other words, requesting for models, we're getting models that include not the appropriate dates that we want, and we have to go back and get those records. So there's a whole litany of issues that are going on now with logistics and the ability to gather the information that the board needs. So it's a problematic issue. And then, of course, I hate to say this, but, we have a staffing issue. And therefore, for the staff to be able to adjust to, as you well know, is that we have lost seven dental pins in our employment. And that really is an impact on the ability for the board to function efficiently. And so not using that as an excuse, because the staff we have is being overworked. But in fact, that is a issue that we're having as well, as far as, response time. Any other issue? Did I answer all your questions, Delegate?
Yeah, you did. But the last one, dentists are generally not affiliated with the facilities that have disciplinary committees, right?
That's correct.
How big is that issues?
Well, if you want to compare it to the physicians board is able to use other auxiliary issues. For example, hospitals and ambulatory surgical centers. They also have belongs to required malpractice, where general dentists do not require malpractice in the state. And so the auxiliary information to get and the coordinated getting information is very difficult because dentists work in silos. And therefore, trying to getting a dentist information is totally dependent on the individual dentist or the group or the corporation they're working in. We were unable to access auxiliary files in order to support that information. So whereas a physician can get information from the hospital because of the quality assurance, we don't have in dentistry that I can contact an quality assurance and say, is this corroborated information or is this other information? I can't contact ambulatory care. I cannot contact various. So dentists, I have to deal with the dentists themselves or that particular group or that corporation. And that's the only information we have access to. If that answers your question.
Yeah, thank you, Edith. Thank you, Madam Chair.
Absolutely. I know I don't see any more hands in the discussion. Do we have anyone else who has any? I see Dr. Grant has something to add. Go ahead.
Yes, just very briefly. Number one, I wanted to make certain that Delegate Krebs had the information that Delegate Bhandari has as well, because
yeah, this report was emailed out to everybody just before the committee, so we may not have had it yet, but they all have it and it will be.
And secondly, I just wanted to add in regards to Delegate Bhandari's questions that during a certain time period, many dental offices were closed. They had to close with the exception of rendering dental emergent care. And many offices closed altogether. So some of the allegations that are put forth in complaints actually require an unannounced visit to an office. So not only were we operating under the constraints of remote staff and limited staff during certain periods of this year, but we were also dealing with the fact that not all of the offices were accessible. Not all of them could access the patient records to respond to subpoenas. And also some of them also had transitioning staff as well.
Thank you for that. Anyone else from the committee have a question while we have all these stakeholders here? I appreciate all of the stakeholders' willingness and commitment to work on this issue over the interim. Delegate Krebs.
Yes, thank you. I was finishing reading the rest of this document. I thank you for the dental board for providing this. But at the end, there's a chart of disciplinary activities. And the thing that I was interested in, you give averages, which number of complaints, board orders, and then average number of days to close. And what I'm trying to figure out is, number one, what is are the people still able to work and practice dentistry during this period of time? Because the average days to close goes anywhere from 148 days to 140. So that question is, are they still practicing during this time? And are there any outliers? I mean, are there any people that have just not had their cases resolved for a very long time?
So I will respond in this way. For those cases that are summarily suspended, for example, the cases.
Oh, we wanted to hear it so badly. There he is.
So anyway, so those cases that are.
Delegate G, I think you're going in and out. Oh, it's me.
Oh, I'm sorry. Let me see. Is that better? Can you hear me better now?
Yes,
Okay.
thank you.
Okay, sorry. My internet here is unstable. For those that don't know it, I'm in Hawaii right now. So my time frame is 6 hours, and we have a storm right now going on, a tropical storm. But nevertheless, in the case of summary suspension, we try to adjudicate those immediately and try to get the offices safe as soon as possible so they can go back to practice. The cases that are under orders or under the guise of the particular order, the order may allow for them to go back into practice, or the order may prohibit them from going back to practice. It depends upon the egregiousness of the case and how the order is presented. We do have some cases that appear to be outstanding, and that's because the case is not closed until all of the provisions of the order has been complied with. So, for example, you may have an order that requires a 2-year probation, that requires board evaluation occurring, and so those orders are not closed until all those provisions are then approved. They are. In most orders, the provision for them to have earlier approval because they have met all the provisions is pretty standard in our order. So in many cases, if a provision has been complied with earlier than requested and has been acceptable, there's a committee that reviews those on a monthly basis so that we can have that dentist go back to work or hygienist go back to work. I must remind you again, is because of the fact that these are legitimate complaints and actions is taken because of verified, violations, that the board is very protective to make sure that office is safe before they go back to work. So it is variable on how that approach, but many of the offices are back to work under the scrutiny of the dental board.
Thank you, Madam Chair. I have one question I wanted to ask someone else, if that's appropriate.
Yeah, absolutely. I know stakeholders came, so if you have someone to ask.
Yes, I mean, I want to ask Ms. Wesker, you've been involved with the board, and where in this process do you see are the hangups, and where should we be focusing our energies?
Well, I'd like to just give a little bit of a background if there's time to do that. So first and foremost.
But let me just interrupt because I messed up and do the injectables bill, which is very important to the committee. So while you may give a little background, I want 3 more minutes on this topic so that we can make sure to pass that injectables bill out. Go ahead.
Okay, no problem. So preliminarily, I wanted to point out that once the dental board issues a license to a dental provider, it grants that individual a vested property right under the US Constitution. So it cannot take away that right without due process, not just any process, but it has to be one that is fair, equitable, and constitutionally sound. During my 6-year tenure as an assistant attorney general and administrative prosecutor, I worked closely with the board leadership. Some of the board members are here today to, among other things, improve the process of summary suspensions of licensees, because the board is charged with balancing the interests of public protection while also preserving the integrity of the dental profession. It is not the board's job to simply wave their magic wand and take away dentist licenses with no good cause and no due process. And so I will say that under COMAR 1044-0722, the board has 2 options if it believes that it needs to summarily suspend a licensee. First, it has to do an investigation. And then it has to decide whether there's a substantial likelihood that the public health, safety, or welfare is at risk. And so if they find that there is this substantial likelihood, it can issue what's called a notice of intent to summarily suspend, which gives the licensee an opportunity to come in and show the board why they shouldn't suspend the license. It's what's called a pre-deprivation of due process notice, saying, we're going to give you a chance to come in and explain why we shouldn't order a summary suspension. In the last 5 years, the board has issued one of those, a notice of intent to summarily suspend. Every other case in which they found that there was a substantial likelihood of harm, they ordered an order of summary suspension, which suspends first and then gives the licensee an opportunity to come in and show cause why that person's suspension should not be continued. In my view, and this is my interpretation of the regulations, that's not the way it's supposed to be. So if I had to look at one thing that is a due process violation in and of itself, is that the board currently jumps over this first step, which in my view is an abuse of discretion, and uses the ultimate hammer, summary suspension, to kill the ant. Because that summary suspension, once issued, destroys the reputation of that dentist, even if the order is later rescinded. And the board seems to either misunderstand or misinterpret what extraordinary circumstances mean, because only in the case of extraordinary circumstances, and not every case can be extraordinary, and after consultation with their own board attorney, can they take the very limited and rarely warranted option to suspend first and then ask questions later. There really needs to be a grave risk and no time to wait. And then they have to provide a show cause hearing within 30 days. My question, first and foremost, is how can every but one case over a period of 60 months be extraordinary? It defies the very definition of the word. And secondly, if the board truly believes after an investigation and consultation with board counsel that this person is so risky, so dangerous that we have to suspend first and then give them an opportunity to show cause, why in August of 2018 did this board decide 14-0 that it would recommend to licensees that they waive their right to show cause hearings because there was no point in conducting them? The board actually said in this memorandum, which I believe Ms. Varanian has, she obtained it through a PIA request, they make clear that the show cause hearing is really not for the protection of the licensee, but really an opportunity for the board to explain to the licensee what he or she already knows is I've been summarily suspended. The show cause hearing is for the licensee to show cause why the suspension should not be affirmed and continued. But the board in that vote did not seem to understand that. I don't know whether their misunderstanding has continued, but what I can tell you is that I have a case in which my client requested no less than 5 times in writing that she be provided with a show cause hearing, and none was ever provided. And that case is pending currently before the Circuit Court for Baltimore City on appeal. I have another case in which an owner of a practice, an African-American female, was summarily suspended following a CDC inspection of the practice, while the other owner, who was in attendance on the day of the inspection, was not charged and was not summarily suspended. Both owners are equally responsible under the board's own statute, but in this case, the female owner lost her license and the male went scot-free. And that is selective enforcement. It is a violation of due process. It's not legal, it's not ethical, it's not fair, it's not equitable. So lastly, I want to say, and I will say this quickly, when the board holds the show cause hearing, which they do not always do, in our particular case, myself and another very accomplished and reputable defense attorney, in our case, we kept asking and asking for the show cause hearing, and we still don't know why we didn't get it. July 7th, it will be 2 years since the summary suspension occurred and since we have asked for the show cause hearing and we're not given it. So
okay, I'm going to stop you there because this has been 8 minutes now and we needed it to be 3. But clearly there's a lot to be said on
A
this,
lot to be said. I could go on for 20 minutes.
but it sounds like what we need to fold into this report are some questions about summary suspensions, notice of intent to summarily suspend, and show cause hearings, and the whole process around that. All
And
right?
the disposition of
I might
these-
add from the dental standpoint is the fact that the board has a different interpretation, as you can guess. It has rationale with some of the issues that Ms. Wesker brings to the table. And we would certainly like to get that across, and certainly in a discussion at another date. I know how busy you are, but I do want to add that there's obviously a different side to what Ms. Wesker is saying. I respect her greatly. I know her, but on the other hand, she does not know the exact functions of some of the issues that the board can bring out as well.
And I would also like to say that the board is very committed to its mission of protecting the public. And yes, in circumstances of egregious infection control violations, the board is compelled to act. As an African-American female, I would like to also assure this committee that the board acts with equity.
Well, I would just like to add to that my client, who was summarily suspended and the other owner was not, is perfectly comfortable coming here to testify before this committee, and is even willing for me to share her name, the case number, so that this committee can look at the situation and realize that that is simply not true in this case.
Okay, so what we're gonna do is we're gonna bring back amendments to the work group bill to turn it into a report. We're gonna clarify the language in the report to include the due process language that Delegate Krebs referred to hopefully at least get some collaborative work, a report that includes stakeholder input. We're obviously not going to find answers to all of these problems with the report, but it's going to be a first step to try and solve problems where we can and work together to try and make sure the process is working for everybody and support the dental board and the important work that they're doing, while also recognizing that we need to make sure that it's serving the public good in a way that isn't unnecessarily burdensome to folks. Does that sound like a good plan to the committee?
Yes.
Okay,
Very good
that's
plan.
all. Excellent. Okay, so that is our plan. And now we'll go back to my boo-boo, which is Delegate Lewis Young's bill. So I think we thought we were ready to do the amendment on this bill, but then something just happened on the Senate floor. So I think we are actually not ready to do the amendment on this bill. Is that right, Lisa? Shall we bring this bill back for the last meeting as well?
I would feel more comfortable. I'd like to actually look at the Senate amendment because I originally thought it was a substitute amendment. Now I'm thinking it's actually an additional amendment. So I just
Let's take some time on it. We have time.
Yeah.
They have our bill, we have their bill. So we have enough time to deal with this at the next meeting. It is the bill that will not go away, no matter how hard we try. So it would be wrong if we didn't wait till the last minute on this bill, I guess, as well. So when we come back to the next meeting, we have to still take up Senator Riley's bill. We have to deal with the dental report, whatever it is, and we will bring back the injectables bill. Everybody should.
We also have the temporary social work bill.
Oh, right. And the temporary social work bill. So I'm sorry we're not done early, but we'll get it all done. I thank the committee very much for their work today, and please enjoy your 27 minutes of lunch break.